After we know what property is subject to probate, the next thing we need to do in the state of Missouri is to admit the will to probate. If there is a will, if the deceased person left a will, we need to get that admitted to probate, and we need to do it pretty quick. In the state of Missouri, a will that is not admitted to probate in court through an attorney in most cases, within 1 year of death, is no longer valid as a will. So it's very, very important that as soon as your loved one passes away, that this gets brought up to the courthouse and an application to admit or to probate the will is filed with the court. It's not enough just to drop it off and have it deposited with the court. You need to file a formal application to probate the will, and this is normally done through an attorney. Okay, and the consequences of that are significant, because if the will is not admitted within 1 year, it's no longer useful as a will, and any of your loved one's wishes that are represented in there are essentially disregarded. Now, in order for that will to be valid, assuming it's filed within time, generally speaking, it needs to be signed by the deceased person or someone else at their direction. It needs to be in writing. Missouri does not recognize holographic wills, so any oral statements or things that are written down in their hand that aren't witnessed are not valid as a will. It has to be witnessed by two people. Ideally, these witnesses are disinterested, or they're not in the will. That's not a requirement, but it's ideal, because anybody who is an interested witness is disinherited if they're not additional witnesses above whatever there would have been their intestate share, or whatever their share would have been without a will. Okay, so if like one child decides, I'm going to give myself 80% of the estate and my sister only 20%, and we're both going to witness it, or I'm going to witness it and she's not here, then that the interest above whatever would have been the default is forfeit. Okay. So a will, it is good that it should also be notarized. It doesn't have to be. It's not legally required that it be notarized, but it is good if it is notarized for the following reason. If a will is, and the witnesses sign before a notary public, and a special a special notary block with special language is included on the will, and if those things are true, then the will can be admitted to probate without further evidence. We don't need to go find the witnesses and get notarized signatures from them to admit the will. We don't need to take any testimony. We don't need to have hearing. In most cases, there's not really going to be much of a legitimate basis to challenge it, if it is validly notarized. Now, there are still opportunities to rebut that presumption and challenge. Did they have capacity? Were they under undue influence and things like that? But as a general rule, assuming there's no major conflicts, the will can be admitted to probate if it is notarized and has all those requirements without further evidence. So it makes things a whole lot faster. And the will generally make the entire probate process much faster. And the way that it does that is because wills will generally do a couple of things. Number one, they'll name a personal representative. So even if you have 12 relatives, you can name one. And what that does is that it eliminates the dispute. It eliminates the possibility that one of your family members is going to disagree and fight the other one for the right to serve. It eliminates the possibility of siblings, for example, who maybe they grew apart over the years, competing over the ability, or they grow mistrustful of each other. It eliminates the dispute that could happen around that. So it allows you to choose an executor. Another thing that's very common is wills will often waive bonding requirement. So in many cases in the state of Missouri, a representative, before taking office to represent the estate, will need to obtain a bond. And a bond is basically an insurance policy that protects the estate. And we'll talk more about that in another video, but it is a cost and it requires underwriting, and there are delays associated with that. And as a result, a will often waive the bond and allow a representative to serve without a bond. So that can save a lot of time, a lot of some unnecessary expense, and sometimes unnecessary, and make things move quickly. The other thing that a will can do is allow for independent administration or unsupervised administration. Now, in the state of Missouri, as in virtually every state, there are supervised forms of probate administration where the court has to enter orders, and there needs to be a hearing before a personal representative or an executor can do virtually anything. In an independently administered estate, the court does not supervise everything. They don't need to file applications. They're allowed to go sell the house, close the bank account, move money around, buy stuff, sell stuff, without needing to get a court order to do all that. Independently administered executors have a lot more latitude than those that are supervised. Now, you can get a representative to be independently administering an estate, even without a will. Is just more difficult because you have to get signed consents from every heir. And in a lot of times that can be difficult or impossible. So if those things are present in a will, it can definitely dramatically expedite, especially the early parts of a probate administration. Okay, but that's the next big step. After we know what the property of the estate is, we need to get that will, the application filed with the court. We need to get it down to the court and start that timeline ticking to see if anybody's going to try and challenge the will. And as soon as that will is admitted, we can start moving on with getting a representative appointed and getting the process moving. Okay, that's it for part 2 of this video series on Missouri probate.